Good evening and welcome to what used to be the meeting for the litigation chapter of the ICLP. My name is Ruzbeh Hosseini and I am the chairperson for the litigation chapter. You may have noticed we've moved to a new format. We've moved to a live podcast model or a live stream model, and every couple of months we'll have a practice issue to discuss with you and with a guest. And you'll be able to join us live and pose questions in our chat box or view a recording of the seminar at a later date at your convenience. Today, I have Mr. Sean Lawler with me. He is a partner at Shibley Righton, and his practice areas include estate litigation, commercial litigation, but for our purposes today, and more importantly, professional negligence and professional discipline matters. Sean is regularly retained by Law Pro to act on behalf of legal professionals. And his experience and knowledge in the area of today's topic, I think, is vital. And I picked today's topic really for two reasons. First, it's an easy topic to discuss and get your feet wet when you're changing formats. But more importantly, I think it's important to go back to basics every now and then and remind ourselves of fundamentals. And we do this at our firm. We go back and remind for the partners and associates the basics of docketing, the basics of legal research, basics of legal legal writing, and so forth. And so I think for today's topic, it's good to go back to the basics of docketing. And today's topic is the do's and don'ts of docketing. Sean, welcome. Thank you for joining me.
Sure. So
I'm going to start with, sorry, go ahead.
I'm pleased to be here. And I was going to talk about my background. Like my experience with dealing with costs comes up a lot in the Law Pro work. Because I pay a lot of lawyers' accounts, I'm sad to report. And so typically, if the lawyer is alleged to lawyer makes a mistake, let's say the lawyer makes a will that isn't good, and then there's a big lawsuit fighting about the validity of the will. And it can certainly happen that the lawyer's mistake in the will leads to litigation. And so then the lawyers for all the parties come and say, well, the lawyer should pay. And so then I get all these bills, and so I end up paying them or not, as the case may be. And I've had the dubious pleasure of having done a couple of assessments. And sometimes it comes up, the Law Pro policy doesn't cover fees, but oftentimes the lawyer gets sued. You made a mistake in litigation, I got a bad result, so I got damages, and you charged me too much to do that. So we're going to your account, so that it comes up in that context. Right.
Absolutely. I guess when you're dealing with wills and estate matters, cases where the lawyer docketed on the file a long time ago, sometimes you have to deal with the issue of, for example, paper docketing versus electronic docketing.
Yeah.
In my view, electronic docketing is, especially nowadays, is a must. But what are your views and experiences on that?
So even before we get to the when you say lawyers who docketed a long time ago, even before you get to the issue of paper versus electronic, the thing that lawyers used to do, which they don't really do anymore, and which shouldn't happen, is these big, I don't know what you call them, like block fees maybe, where lawyer says, to meeting you, preparing a will, meeting you again, and doing all kinds of work for you. It's like a big long paragraph, and at the end it says $10,000. And I don't know how lawyers were able to do that, but certainly that's long gone. So nowadays the sort of mode is you have to account for your time. The exception for that, there are certainly going to be lots of lawyers where you give block fees in advance, where or you've got And that could be, you do a will for $1,000 or 500 or whatever the number is. Or there can be fee arrangements where, even on big files, we're going to bill you $10,000 a month, and that's what it is. And so, but generally speaking, the mode is of docketing and recording your time. And I know you've asked me about electronic docketing versus, but I do want to just step back, because what's the lawyers have to remember is that the way the system is set up is to address the basic problem, which is that lawyers owe their clients fiduciary duties. Okay, and that obviously means lawyers have to act in the best interests of their clients at all times. But it's not in the lawyer's best interest, in the client's best interest to pay. And of course, the lawyer has to get paid. And so and the other problem is the lawyers have, not always, but in many cases, all the knowledge and sophistication about the legal process. They really hold the whip hand. It's hard for the client to negotiate what's reasonable, what makes sense, what's fair. And the lawyer has tremendous power. I know it doesn't feel like that when you're working on files and the client calls you at all times with unreasonable demands, but the way the system is set up, the lawyer does have a lot of power. For instance, oh, you don't like what I'm billing you, I guess I won't do any more work on your file. Or oh, you want to get someone else to replace me, I won't give them your file. Like, those are practical realities that the client has to contend with. And the lawyer has the power to get like charging orders. So you can go to court and say, I get a piece of whatever you recover. And so the lawyers have these fiduciary duties, they have these strong powers, and there needs to be a way to make sure that clients are treated fairly. And that's the whole assessment process. And so, whatever we talk about today, or whatever you talk about docketing and billing and stuff, I think the reference point has to be, like, the lawyer has to be thinking assessment process. What happens if my bill gets assessed? And so I really don't want to read law out loud, but the two big things are the Solicitors Act, which, using the 19th century's best language, sets out like the process with the bills and assessments and when you can do it and so forth. So you look at the Assessment Act, the Solicitors Act, and of course the Rules of Professional Conduct, Rule 3.6, our Section 3.6 of our Rules of Professional Conduct talks about fees, and it says, specifically, a lawyer shall not charge or accept any amount for a fee unless it is fair and reasonable and has been disclosed in a timely fashion. And the rule talks about what that means. So, even if you never expect to be inside of a assessment office, and I can tell you from bitter personal experience, it's like having your liver pecked out. All right, you have to always be thinking, what happens if my account gets assessed? Is it transparent? Can people understand it? We'll talk about that in a bit. So with that really verbose background, the question is electronic docketing versus paper. And I don't know that there's like a magic answer to that. So, because for instance, you can call my dockets paper, even though I don't use paper, I use a Word document, and it looks like a paper docket, and I record all my time on it, and then it goes to my assistant. But whatever the system you use is, you have to make sure that you can record your time like contemporaneously, and that there's enough space and flexibility to record the time and the explanation. And my firm uses PC Law, and I've got partners who have the PC Law screen open all the time, and then they enter it. I don't know that there's any actual magic to that, so long as you're disciplined about having like all your dockets in one place. What I see where lawyers suffer is when they make it, they have a phone call with a client and they're good at making a note of the phone call, and then they just put 0.3 on the note. You really got to have it in a central location so that whoever posts the dockets it's as easy as possible for them. Because if you have it on a note, it's much more likely that you're going to lose it. So my own view is that it doesn't really matter so long as you have a disciplined, consistent system.
Yeah, and I think the point of that is you want to eliminate errors to the best of your ability.
Yeah.
Because it's in the errors, in my view, that you then run into problems such as not docketing fully for your time, so you're losing money, or overestimating how much time you spent, and that can get you into the opposite problem.
Yeah.
Of having to explain to an assessment officer, why it took you X amount of time to do the work.
Oh yeah. And so the way assessments work, like the sort of nuts and bolts of it, is that you get to the hearing and you've got your bill, which should be detailed, like we talked about, not the block fee. And so it'll say, well, 0.4 letter to, or let's say 0.9 letter to client. And the assessment officer says, well, why was it 0.9? And if you've got like a 2-line letter, confirming our meeting tomorrow, that could be, doesn't have to be, but it could be a problem. So you got to have some explaining. So you have to make sure that the time matches the material. And like the other problem is sort of, I think, more common. Like my experience is lawyers don't exaggerate the time they spend. Really, like they spend the time. The bigger problem is they miss time, and it sucks to like not have a docket, and then you're trying to persuade the assessment officer of what you spent 2 hours preparing for an examination for discovery, and you've got no docket of it, and you will not get it. You can't, like, it's not going to happen. So your system has to be inclusive enough, and the system really should allow you to, like, ideally, if you're using electronic, it'd be what's great is if you can go back to a file, turn on the clock, work, turn off the clock, go to another file, and come back to it later on. That gives you the flexibility. Maybe that's an advantage of some of these systems. The problem then becomes, of course, it's always human error. You're going to forget to switch off the clock one time, and it'll be like 9 hours for writing a letter, and then you've got to sort of work backwards.
Go back.
But as I said, my observation really is the problem really is missing time more than, like, it's funny, the layperson's complaint, the sort of backhanded complaint is, oh, well, he's, whipping up time when it doesn't exist, or he's making work where I don't think lawyers do that. I mean, I guess it happens, but that's not the real problem. Is the other way. Lawyers generally are conscientious, and they mess up and they miss time. That's the big.
I agree, and I think it's important to obtain good habits and maintain them. So for example, Sean, you have your way of docketing, and it works for you, and you've probably done it for a long time, and you're used to it. My way is the way that you described, where the lawyer has PC law open at all times.
Right.
And that's the way I work, and I've done that for 12 years of practice. And I use the timer constantly, stop, start, stop. So yeah, once in a while I forget to stop it. It happens. Okay, and I do get that letter for 9 hours. Then I have to go back and figure it out. But that's rare. And
it's okay to make mistakes. Like, it's not a crime
to
forget to turn off the clock.
That's right.
And do you docket for like, even if it's admin things, or like, do you record your time for all that stuff?
So, for example, in our firm, we don't docket for admin work, and that includes clerical staff as well. They're not supposed to docket for admin work. Admin work being, for example, writing to the court to ask for dates for a motion, for example.
Right.
Filing documents. These are all this is all admin work that you typically shouldn't docket, right? And sometimes, Sean, I mean, you can maybe get into this. Sometimes it's difficult to know what's clerical and what's administrative. Do you have any thoughts on that?
Well, so I want to back up for a second. So I do what you do, okay? I don't docket, but if you go looking at the CLEs on this stuff, the wisdom is docket for everything, because what you and I have not talked about yet is that docketing. I talked about the assessment office and protecting yourself, but it also is information about how you spend your time, and like that's what we sell, and our dockets and the WIP that it becomes, that's the inventory, and you need to know how much inventory you have, and so anyway, but I agree with. I get nervous, like if it I worry that I'm going to I'm not going to edit properly or something, and it's going to be. But the wisdom is docket for everything. And so, what's the difference? It really depends on what the client wants. Law Pro only pays half of travel time, and these days, or last 2 years, travel time has meant from the kitchen to my office upstairs. So I don't really have trouble billing. But that's a rule, and I think it's funny. I was just talking with another lawyer this afternoon about this. I think that if you're applying a lawyer's skill or a clerk's skill, because all these rules apply to clerks, and sometimes hashing things out with the trial coordinator's office or getting it, that there is skill in that. There is a requirement. It requires lawyers' time. So to me, it's what the client wants, and what and what is really a professional skill. And you got to keep in mind, coming back to the assessment aspect of it, the reference point these assessment officers go through is there's a case from 1985 called Cohen and Keeley, and it sets out these 9 factors. What's a reasonable account? Okay, how much should the client be paying? And you look at the time lawyers spend, the complexity, the responsibility assumed by the lawyer, and all these other things. But first and foremost is what did the client agree to? If I'm charging, I once paid a lawyer's account, and he was charging $1,000 an hour, and once I got past my envy, it was in all of the circumstances reasonable. It's what his client agreed to pay. He's a big shot tax lawyer, and his time was reasonable in all the circumstances. And that's something he worked out with the client. The fact that I had to pay it is another problem. But so it's what does the client agree to, and what did the client really expect? Do you need $1,000 an hour lawyer calling the court? No. Do you need 2 lawyers attending examinations for discovery? Many clients, institutional clients, will have a very jaded look at that. But maybe sometimes I once lawyer and I, we were the same vintage, and she needed my help because I had experienced this, and the client was cool with it in the circumstances. So you got to have a good relationship with your client, and by that I mean a clear relationship. Having a good retainer agreement helps. Talking about all these things, and then recognizing that you're always going to be tested against a standard of reasonableness. And Rule 3.6 of the Rules of Conduct talk about that. And this case from 1985, this Cohen case, talks about that. Is it reasonable in all the circumstances? Again,
no matter what.
You ask a simple question, I give you a long-winded answer, but that's my full answer to your question.
Yeah, and that's no matter what's in your retainer agreement, right? So you're always judged by that factor of reasonableness.
And this gets back to my opening speech about fiduciary duties, like, because the lawyer holds the whip handle always is the attitude of the courts. And so you can't be fancy. You can't say in your retainer agreement, and the client agrees never to assess the lawyer's account. Can't do that. You know,
Yeah, that's right.
You can always be taken down. Always
That's right.
be taken down. And good luck trying to get it on a sister client assessment. Good luck trying to get more than you billed. Like that ain't
That's
happening either.
That's right.
So it sucks. The assessment process, it sucks. And I don't mean it's, and what I mean by that is that, you know, you do the work, and then the client says, I paid too much, and you're only going down in an assessment, and that sucks.
Yeah.
Whether it's fair or just or whatever is not what I'm talking about. As the lawyer who does the work, you want to get paid what you think is the fair amount. So
yeah, that's right.
So there.
Yeah, and you're putting the judgment on whether it's fair and reasonable in the hands of somebody else. You know, and that can be a tough thing to do.
Yeah.
And while we're on the topic of, you know, proper docketing practice specifically, you know, what do you say about, you know, those individuals who will docket contemporaneously versus, you know, a lot of lawyers leave all of their docketing to the end of the day, end of the week, end of the month.
End of the month. Oh. It makes some, I've got partners who do that, and some.
So do I.
And it makes us crazy.
Yeah.
It makes us crazy first because if that person isn't the one who's doing the billing, isn't what we call the responsible lawyer, you're like waiting to the last minute. And again, the lawyers end up guessing, and my experience, they guess low. They guess low because no one wants to seem dishonest or taking advantage. So like I can't say I don't do contemporaneous. Okay. I'm pretty good. I do by the end of the day, I've got a full docket, proper docket, not contemporaneous, but ideally you do it contemporaneously.
Yeah.
Ideally you do, and then you do the editing and everything else when you render the account. That's when you assess for yourself. You decide for yourself whether this is too much. Oh, I can't believe I spent 5 hours on that preparing for discovery. Well, will the client take it? Maybe, I don't know, but at least you know. And if you're spinning your wheels, at least you know, and you can, like, there's no shame in it if you're able to assess and evaluate your own work product.
That's right, and your own efficiency.
Yeah,
that's right. That's right. And you know, as litigators, we all know that memory is fallible. Okay.
Yeah.
You know, if you have to rely on eyewitness testimony, for example, okay, you might get, if you interview 2 or 3 people who saw the same thing, you may get different answers. That happens a lot, and that just goes to show why waiting to docket is a bad idea, because you won't remember how long you spent. It's really important to docket contemporaneously, or, you know, as soon as possible if you can't do it contemporaneously. We have one question, and I think you may have answered this already, Sean, but I'm going to ask it again just in case. There's a question from a viewer that says, if the retainer with the client is on a flat or block fee basis for a specific service, is it recommended that the lawyer still keep detailed dockets in its file, setting out exactly how much time the lawyer has spent on the file, or is this unnecessary given the flat fee arrangement?
So I have looked at a lot of lawyers' accounts and their block fees, and they don't keep dockets. And how about this? The reality is, by and large, if these are not huge accounts, if it's like a $2,000 for a real estate transaction, or $1,000 or whatever the number is, if it's modest, I don't know if I can ever say don't worry about it, because you could always be assessed and you'll be asked the question, so how much time did you spend on it? Okay. But there is, I think, a reality that if you've got a practice where you're doing a will a day, and you know what it takes to make a will and so forth. I mean, you know, the safe thing to do is keep dockets, because if you're challenged, you can have a problem if you don't. But I think the reality is most lawyers don't, and for those kind of files. For bigger ones, if it's big bucks, whatever that may mean, I think you should, because you're always going to be subject to the fair and reasonableness test, and it's going to matter. And the first thing you do when you get to the assessment office is the officer will say, okay, well, what's the retainer agreement? And you say, well, look, sign agreement, $10,000 a month. And that will be a factor, for sure it will, very important factor. But if it turns out you haven't done a stitch of work on the file for 6 months, and then the case went badly or whatever, that you'll have a problem. So I don't know how well I've answered your question. The answer is a lawyer's answer, which is it depends. But the bigger the numbers, the more cautious you should be.
And I'll add to this. Okay, some people don't like to hear it, but it's true. We're in this business because it's a profession and we want to help people, but we also want to make money. Okay, and flat fees or block fees, the way they're typically calculated is the lawyer will determine generally how long it will take him or her to do the job, and then the block fee is based on that amount of time, because that's what we do as lawyers. We sell time. If you're not docketing regularly, then you may not know how much time it would take to do the matter. Then you're losing money potentially.
Yeah.
Okay. So it's you may not need to docket. I'm with Sean. Yeah, I think you should always docket, even if it's a block fee, even if it's a flat fee or whatever you call it. I think it's important to do that. Here's a good one, Sean. How much detail should go in the description of the docket?
Nice. So imagine yourself with the assessment officer, okay, and you've spent 3 hours to paperwork. You then have to go, you'll have to go through what that means. And so you show your file, like, what does that mean? And so that won't be enough, like, to paperwork. The flip side, 3.0, and you spend, like, you write a book, that can get you in trouble the other way. So the answer is more detail than you think, but up to a point. So the real question is, can you identify how you spend all the point ones? Are there 3 tasks where you want a phone call for point 3, and then did you review the plaintiff's motion record for point 3, and then did you do research for point 3? You should say that. You should break down so that you can identify clearly what you did, and so that when you connect the time with the paper, it makes sense. Or if you have a phone call, 0.4, phone call with client resettlement. Okay, well, that can take 0.4 for sure. 0.8 phone call. What? 0.8 phone call negotiating wording of release with defense counsel. Okay, that makes sense. Can the assessment officer looking at this say to him or herself, okay, yeah, this makes sense, this is fair and reasonable? The tricks you then get into is, careful not to put in privilege stuff. 0.8 telephone call with client. It took so long because I had to persuade him he had a bad case. That's a problem. That's a problem if you ever have to show your dockets around, as you may have to if your file is assessed, as you may have to if you you win a cost award and you've got to show the judge your dockets. So as much as is necessary to allow the assessment officer to say, oh, okay, yeah, that makes sense.
That's right. And I want to emphasize, dockets in and of themselves are not privileged. Okay, they are producible potentially, depending on the circumstances. All right, your communications with your client obviously are privileged. So, for example, if you send a bill to the client, that's communication with the client, that's likely privileged. But the dockets themselves may be evidence. So it's really important not to write down privileged information in your dockets. That might end up getting you in trouble.
Yeah.
A user, sorry, not a user, a potential viewer prior to today had asked, what software we recommend to use it for docketing. And before I go to the next step, Sean had indicated that his firm uses PC Law.
Yeah.
My firm also uses PC Law, but there are other there's a lot of software out there that does much the same thing. I think the key here, okay, is to just be careful that not all accounting, docketing software is the same. For example, we use PC Law because, notwithstanding the fact that it's, in my view, this is my opinion, a little clunky and old, it's a full-featured accounting software.
Yeah.
Okay. Other newer pieces of software that lawyers use for docketing, they do a fantastic job. They're very easy to use, very pretty, but they may not be as full-featured. So it's really important to do your due diligence and ask the right questions when you're going to buy into a piece of software, that you know exactly what it is that you need.
And try them out.
And try them out, yeah, and ask the people that are selling you the software, is it full featured? Does it have everything that I need, or do I need to add QuickBooks in addition to? Okay. But other than that, there are some competitors to PC Law are Clio, there's Abacus, MyCase. I mean, we could go on. There are lots of different pieces of software out there. I think one area that we haven't discussed yet, which I think is important for the purposes of docketing, and that is just generally being organized. In order to be able to docket effectively, Sean, and let me know your thoughts on this, but you need to know how your day is scheduled. But also, you need to be organized enough, in my view, to be able to avoid distractions. If you're constantly getting phone calls, you're constantly answering text messages that your clients send, and you're constantly responding to emails while you're trying to do the factum, okay? Aside from the fact that you may not be doing a good job on your factum, you may not be docketing accurately, okay? Because you're not going to be able to determine how much time you spent, in my view.
Yeah. So when I was a new lawyer, someone said you should never work on more than 6 files in a day. And I don't know whether that's true or not, but like in the sense, I don't know if that's like a conventional wisdom. I don't know. I can't remember the person who told me. I can't. But I always think of it because my practice, if you're a plaintiff's lawyer and all your files are brain injuries, you may have 5 or 6 huge files on the go. That's not me. I have lots of smaller files, basically. And on those days when I'm caught up, and it's a flurry, and I've worked 10 files in a day, that can be more chaotic in terms of docketing. So I don't know if you can have a reference point for what's too many files to work on, right? Internally, that could be helpful.
Yeah, and I think it depends on your practice. Even if you're in litigation, it depends on what kind of litigation you do.
Yeah. If you've got a high volume, real estate practice, you may be on 15 files a day.
Right.
And then about time management, we had a time management person come in a couple of years ago before the pandemic hit, and I can't remember her name, but I will look it up if people are interested in having someone speak to them about time management. And if you email me, I will find the name of this person who was very good. And one of the most interesting things she said, which was that only look at your emails twice a day. And everyone was like, no, you can't do that. That's crazy. You gotta, da, da, da. And then she gave all these examples of heavy hitting lawyers who look at their emails twice a day. And I mean, like all this stuff is about discipline. Like, so, you know, so much of the profession is about discipline. And if you can stick to that kind of good regime, I bet your docketing will be better too. You know, because she says you go in, what's your day going to be like? Of course, you're not going to get it all right, but what's your day like generally? Look at your emails in the morning, do a day, look at your, like, so if you can bundle all that together, you know, that's how you have an administratively peaceful law practice.
That's something that I have to improve on, I'll tell you. Not checking my emails constantly.
Yeah, and then stupid texts and WhatsApp, and your kids call you like, oh yeah, bananas.
That's right.
Yeah,
that's right. Yeah. Well, listen, Sean, I think that covers it. Do you have any other things that you want to say?
No, I think I hit all the high points.
Yeah, you did. Well, listen, thank you very much for joining us.
My pleasure.
If anybody has any questions, and now's the time to ask. But if not, then you can always reach me, and certainly I'm sure Sean will be happy to receive any questions that you may have.
Yeah, you bet.
And I see there aren't. So, okay, great. Sean,
okay.
Thank you very much for taking the time.
Right,
and to all of you, thank you for joining us either live or later on. And I hope you join us later. Take care.
Take it easy.
Bye-bye.
Bye-bye.